Good afternoon, and thank you for joining us for today's webinar, Purchasing with Federal Grants, Proper Procedures and Allowable Costs. This is the third and final in our series of federal grants management webinars. The first was held on March 24th and addressed indirect cost rates. The second was held on March 31st and covered the various types of grants and contract relationships between subgrantees and federal grants under federal guidelines. Today's webinar will provide invaluable information about procurement and allowable costs with federal funds. I'm Lori Thompson, Deputy Director of NATO and the NATO Research Foundation. On behalf of NATO, thank you all very much for joining us today. As with the other webinars in the series, today's webinar was designed for non-finance staff. It will explain the purchasing methods that are acceptable when spending federal grant funds and demonstrate how to justify and document the costs of the most common goods and services you buy to support your awards. For those of you unfamiliar with NATO, we are a national membership organization of the country's 540 regional development organizations, or RDOs. RDOs might be called different things in your region, such as councils of governments, economic development districts, area development districts, regional planning commissions, or some other. These entities all work at the regional level to assist local governments and communities by promoting economic development and place-based strategies in the areas of housing, transportation, infrastructure, and workforce development. The NATO Research Foundation is a nonprofit research affiliate of NATO. We work on a variety of projects to identify, study, and promote regional solutions through research, training, and peer exchanges. Before we get to the presentation, some quick housekeeping notes. At any time throughout the webinar, please type your questions into the question box on the side panel. We will try to get to as many as we can at the end of the presentation. Also, we are recording this webinar and will be made available to all registrants within the next couple of days. You should have received a copy of today's presentation and a handout with information about federal procurement by email this morning. If not, the links to the presentation and handout are included in the chat box. With that, I'd like to introduce today's presenter, Bob Lloyd. Bob is an expert in all areas of federal grants management. He is a respected authority on policies and practices on the award, administration, and oversight of federal grants, contracts, and subawards. He has more than 40 years of experience in federal award implementation. Bob has served NATO and our members on numerous training and advocacy engagements. And with that, I'd like to turn it over to Bob Lloyd. So Bob, whenever you're ready, please start the webinar.
Okay, well, thanks very much for that introduction, Laurie, and I'm glad to be back with everybody for our third session. You know, when you look at an approved budget for a grant award, it's pretty clear that you usually have two prominent chunks of direct cost expense. The first are costs of people, that is, salaries, wages, and fringe benefits. The second chunk is the cost of purchases of supplies, equipment, real property, and services. So today we're taking on the rules for that purchasing. And these are part of a larger set of rules known colloquially as the Super Circular. The Office of Management and Budget refers to it as the Uniform Guidance, and the official title is Uniform Administrative Requirements, Cost Principles, and Audit Requirements. Well, within that larger set of regulations, there are several what are called system standards, and the procurement area or purchasing area is one of that set of system standards. Now, let me give you just a little ancient history on this because it is illustrative of what the product of these requirements is. In the late 1960s and early 1970s, there was a major effort undertaken at the federal level to provide for uniform administrative requirements. The first group of grant performers that were subjected to this exercise were state and local governments, because back then, and certainly is true today, state and local governments are the biggest recipients of federal grant funds. Colleges and universities, hospitals, nonprofit organizations are certainly big players, but the largest federal aid programs tend to be state administered or directly funded to larger local government entities such as cities and counties, and in some cases, regional organizations. So when the federal government decided to put together uniform requirements so that all federal agencies would do things the same way vis-a-vis recipients, it was pretty clear right off the bat that they didn't need to instruct public agencies on how to spend public money, because those organizations were spending a lot of their own source revenue. So the assumption was that they would not give away the farm, if you will, with their own money, so that there was certainly a willingness to try to rely to the maximum extent possible on the requirements that organizations already faced without any federal funding involved. And so even though there was considerable unevenness among governmental units in terms of the way they did business, what the Office of Management and Budget, working for the administration, decided to do was to introduce minimum standards where organizations could certainly exceed the standards. In many cases, they had to because of state law or other internal requirements, but those minimum standards would create a floor under which organizations were not supposed to go. And organizations that didn't meet the minimum standards needed to bring their systems up to those standards in order to properly administer federal funds. So the current level of those standards is what we're really talking about here today. Now, I recognize that virtually all of you are not starting from a standing stop. You've already got purchasing procedures in place, but there have been some significant regulatory changes over the past several years that may or may not have been accommodated by your organization. And I'll introduce this without pointing any fingers, but the way you've always done it may not be correct. And so perhaps you're going to hear some things today that will surprise you in terms of what is actually expected. Now, it's also good to see who is here. Laurie provided me with a listing of organizations and position descriptions of the folks who are attending. And what I was struck by is the mix of financial and executive personnel, as well as people who are responsible for particular types of program implementation. Because in some of the federal aid programs that your organization administers, procurement or purchasing is the big activity. If you blow that, you've blown the grant. And needless to say, the awarding agencies that are providing those grants are particularly interested in the way you go about purchasing. Now, let's move to the slide deck and slide number 2 and talk a little bit about where these procurement standards are buried. Title 2 of the Code of Federal Regulations is called Grants and Agreements. It is the parking place for all of the government-wide and agency-specific grants management policies. So 2 CFR 200.317 to 327 are the sections that deal with that. Now, that's about 6 pages of federal regulation. And it's interesting, or it should be interesting, that the federal government is telling you in 6 pages how to do something that it takes 7 books for them to tell themselves. On the slide, you'll notice one of the sub-bullets there refers to something called the Federal Acquisition Regulation, which is contained in Title 48 of the Code of Federal Regulations. That's where all the policies related to how the federal government itself engages in purchasing are buried. And not surprisingly, particularly in the aftermath of the pandemic, I should say, and the amount of federal funding that's been forthcoming, the Federal Acquisition Regulation has certainly received a lot of attention in terms of how the federal government would proceed to buy some of the things it has had to buy, like vaccines, for example. Now, as the slide points out, these sections related to grantee procurement are really skeletal features. You're going to be adding some detail to your own policies to flesh those skeletal features out. The other thing I should mention is a citation to Appendix Roman numeral 2 of 2 CFR 200. What that is a listing of all of the so-called boilerplate or standard clauses that have to go into a purchase order or a contract that is undertaken with federal funds. And we do not provide that to you here during the webinar, but we'll be following up with an email which will include those matters as well. And that will give you one of the tools that you're going to need to use in going ahead and purchasing with federal funds. Now, the other warning or caution here is that the Federal Acquisition Regulation doesn't apply to recipient and subrecipient procurements. It doesn't apply to you. But that doesn't mean that somebody at the federal level might mistakenly try to apply it to you. And that's something you need to be on guard for. Now, the Federal Acquisition Regulation addresses the same life events in the life of a purchase, but it addresses them in a different way. And so differentiating what are called contracts under grants from federal contracts is an important step. Now, let's move over to slide number 3 and talk a little bit further about what we have in those policies. And the first focus is the federal government's grant purchasing philosophy, or what I refer to as their philosophy, which is to build on what I mentioned a few moments ago. You're allowed to use your own procurement procedures if they meet the standards contained in 2 CFR 200, 317 to 327. And you also must apply those requirements uniformly to both federally financed and other activities of your organization. In other words, the intent is that you've got one purchasing system that you use for all of the purchases your organization undertakes, whether they're federally funded or not. Now, you might say, well, where does that come from? The title of the webinar refers to allowable cost. And the reason it does is that in order for a cost to be allowable or chargeable to the federal government, it must meet a number of what are called general tests of allowability. And these general tests have to be met no matter whether the cost is specifically listed in the federal cost principles as being allowable. And most of you have heard the general tests of allowability railed off in front of you before. The costs must be necessary. They must be reasonable. They must be beneficial or allocable. They must be consistently treated, adequately documented. And one of the criteria is that they be applied uniformly to both federally financed and other activities of the organization. So in order to charge a cost to the government, if it is a cost involving purchasing equipment or supplies or services, you must have run it through your purchasing system, which meets the underlying standards. And the failure to do that could lead to an auditor or somebody else questioning the cost of that transaction. Now, question costs are not necessarily always disallowed, but that's a major step in that direction. People say all the time, well, the auditors disallowed the cost. The auditors don't disallow costs. They question the cost. The awarding agency, whether it's at the state level for a pass-through type of grant or whether it's directly from the federal government, the awarding agency is the one who decides whether the auditors are right. And if you didn't go through the right procedures, you run the risk of having them agree that the cost should be disallowed. Now, the regulations differentiate between purchases made by state governments and purchases made by other kinds of organizations. And the other kinds of organizations include local governments, regional organizations, nonprofit entities, colleges and universities, hospitals. Okay, all of those entities are now covered under a single set of regulations that, as I indicated, is known as the Uniform Guidance. But OMB, the Office of Management and Budget, differentiates for purchasing purposes between what the state governments can do and what others can do. Now, the reason they do that is, among other things, most of the states have adopted purchasing procedures that were modeled on something called the Model Code for State and Local Governments. This is something that was developed by the American Bar Association back in the 1970s, and at least 45 states have adopted all or a portion of that model code. So the assumption the federal government made is if the state government adopted the model code, it's got a set of purchasing procedures that aligns very nicely with what the federal government expects in terms of accountability for the funds. Now, let me mention one other thing that is probably going to be relevant to a number of you. The state government, through the state legislature in all likelihood, if they've adopted a set of purchasing procedures for state government, that may be different than what is required under state law for non-state governments. In other words, there may be a separate state statute that says here's how county governments are supposed to purchase, or here's how local governments generally are supposed to purchase, or school districts. The degree to which the state government has differentiated among various parties in terms of their responsibility for purchasing activity may be pretty significant. I know, for example, in the state where I live, the state government has a very extensive purchasing law that applies to them. But within that state law, there's a single provision that says that units of local government, and it then defines local governments, will have a purchasing system that provides for competition. And then it goes silent. So local governments have significantly more flexibility in designing their purchasing systems than the state government itself has. So the question of whether you've got to follow a particular state government policy may have to do with your status as an organization rather than your status as a recipient or subrecipient of federal funds. Now, let me explain something else that's been kind of problematic in terms of the standards that we're talking about here. The federal government went through a process of revising the uniform administrative requirements and cost principles and audit requirements back in 2012 to 2014. It was a major initiative of the Obama administration. And so one of the objectives of that was to put all grantees, all types of grantees, under a single set of rules and to stop differentiating based on whether somebody was a governmental unit or an institution of higher education or a nonprofit organization. Putting everybody under the same set of rules was seen as a valuable simplification process, and to some extent it has been achieved. But when that happened, there was a lot of grousing, and much of that grousing came from a sector that's known for grousing, and that's the higher education community. They are far and away the most active sector when it comes to dealing with grants management issues. And their whole approach to things is that they're special. And probably a lot of you who know business management people from a university know that kind of carries over. But without getting too nasty about them, let's point out the fact that when they saw what the procurement standards were in the revised regulations, they had some real heartburn over that. So much heartburn that they went to OMB and demanded that they be exempted from the requirements. Well, OMB wasn't going to exempt them, but they took the unprecedented step of delaying the effective date of the implementation of the requirements. Initially, they deferred it 1 year from the end of 2014 to the end of 2015. And then when it got close to the end of 2015, there was more grousing, and so they deferred it for another year to 2016. And then did it one more time to the end of 2017. Well, by that time, the universities had gone up Capitol Hill and told members of Congress how special they were and how difficult it would be to implement the requirements as written. So one of the things that Congress did was they interceded and wrote some legislation, which you will see the upshot of as we go through our presentation here. Suffice it to say that some of what you have to follow now comes as a result of statutory, I won't call it meddling, but certainly statutory action by the Congress itself. Now, one other thing to understand in the broad context of federal grant administration policy. Included in the uniform guidance when it was issued at the end of December 2014 was a statement that OMB promised to conduct a review of the regulation 5 years out from its effective date. And so that provision, it wasn't very noticeable at the time, showed up in terms of requests that organizations made to OMB for a relook at the standards that were presented. NATO was involved actually in reminding OMB of their commitment to review the regulation. And toward the end of 2019, that took on a life of its own. And in January of 2020, OMB proposed revisions to the regulation and asked for public comment on those proposed revisions. The public comment period began on January 22nd, 2020, and was scheduled to end 60 days later on March 22nd of 2020. Well, then COVID showed up, and so the regulatory review process had to run parallel with the unprecedented actions that OMB took related to the deferral of activities and shutdowns and so on, as well as the passage of the CARES Act at the end of March 2020. So there's clearly been a lot of stuff going on at the same time. Well, the proposed revisions were finalized in August of last year and took effect on November the 12th, 2020. And it is in those regulatory revisions that some of the purchasing policies that we're talking about first emerged. So what we really have for the first time in about 5.5 years is a solid understanding of what is expected in terms of purchasing. Now, you don't have to be all that interested in the process that got us here, but certainly in terms of being able to explain why some things are the way they are, knowing a little of that history is important. Now, the other thing to keep in mind is the distinction, and this is something that was shared with those of you who attended the program last week on playing well with others, about the nature of a contract under a grant. A contract under a grant is what's called a lower tier relationship. It's not an arrangement that takes place between the federal government and a prime recipient. It's something that happens once a grant is awarded, and somebody in that grantee role has to engage in a form of purchasing. Now, the so-called pass-through entity, which is that primary grantee, has to make a case-by-case determination of whether the transaction that they're getting into constitutes an assistance transaction or a procurement transaction. And those terms are very, very important because a procurement transaction is joining a buyer and a seller together. Now, On slide number 4 is a chart which illustrates these concepts graphically and is actually make it a little easier to understand. At the federal government level, there's a statute called the Federal Grant and Cooperative Agreement Act, which establishes the basis for the federal government to enter into financial transactions. And it makes the distinction between federal assistance, which is the left-hand side of this chart, and federal acquisition or procurement, which is the right-hand side of the chart. Now, as you can see from the right-hand side, the federal government's relationship to a contractor is one of purchase, and the federal acquisition regulation, which I referred to earlier, is the set of rules that governs how the federal government's going to buy stuff, whether it's a weapons system or it's office supplies, or maybe it's training services, or something where people like myself become a federal contractor, or even organizations like NATO do. Okay. Now, on the left-hand side of the chart is what we have known as federal assistance. In federal assistance, the federal government's purpose is to assist, stimulate, or support a non-federal party, notice how broad that term is, in the conduct of a public program authorized by law. Well, that grantee or recipient, also known as a pass-through entity when it deals with the lower tier, has to decide whether what they're doing is assisting somebody or purchasing from somebody. The assisting somebody involves a transaction known as a subaward or subgrant to a subgrantee or subrecipient. The important thing to remember about that is the federal funds do not lose their identity when they flow from a grantee or recipient to a subgrantee or subrecipient. On the other hand, when the grantee or recipient goes out to purchase something, regardless of the type of organization they are purchasing from, then that transaction is a buyer-seller relationship. And when the contractor under the grant is paid for value received, the federal funds lose their identity. The contractor has earned their money. Now, the federal government's interest in that transaction is that the grantee or recipient get the best deal that they can. That, colloquially, that they shop around, they pick the best contractor to do the work or to provide the goods, and they get what they pay for. They follow up to assure that there's delivery of what was expected. And so it is those rules that we're dealing with here in this discussion. Now, we may come back to slide 4 occasionally for further clarification, because where you sit in that chart determines what rules you have to follow. Let's go over to slide number 5. As I've already pointed out, the federal government's rules for grantees involve reliance on your own organizational procedures. The federal government is not a party to a contract under a grant. The recipient or grantee is, or in the case of a subrecipient or subgrantee, they are vis-a-vis their contractor. And so knowing who the parties are is important. Now, in the regulations that you have as part of your handout material, in section 318K, there is a discussion about the non-federal entity, meaning the recipient or subrecipient, being the sole authority for all matters arising under its procurements. In other words, you're the buyer, and you decide how you're going to go about engaging in pre-award activities so that you solicit the marketplace in an effective way and get competition to the extent possible. And you conduct what are called source evaluation and selection procedures. Now, that's a formal way of saying You look at the offers you received, whether they are bids or proposals, and after reviewing them, you select the successful contractor. And so transparently showing how you made that decision is a big part of your pre-award activity. Once you've placed the purchase order or contract, then you are also the sole authority for dealing with post-award matters, such as interpreting the terms and conditions of the contract and dealing with any claims that may arise from the contractor with respect to being paid or having remedies related to whether the contract has been breached. Now, it's at this point that the federal government reintroduces itself. In Section 200-325, it makes clear that a federal awarding agency can, on request, review purchasing documents and other aspects of a particular purchase to determine whether the organization has properly carried that out. It also gives the federal government the authority to review the purchasing procedures to assure that they meet these standards. Now, that doesn't mean that the federal agency will necessarily do that, but it gives them the authority to do so. And there are some agencies where that comes into play. I know, for example, there are several of you who come from metropolitan planning organizations that may be part of a larger council of governments or regional entity, where the Federal Transit Administration, a unit of the U.S. Department of Transportation, might engage in just that kind of behavior. The Environmental Protection Agency is also known for doing some of that kind of thing. But clearly the feds don't have the resource people to do that to everybody. So they probably do it in places where there's an awful lot of procurement going on, or where there's a concern that the procurement that is going on isn't being carried out consistent with these standards. Now, let's move over to slide number 6 and talk about how the people who are involved in purchasing under grants are supposed to behave. You're supposed to develop a code of conduct that tells people who are involved in purchasing decisions how they are responsible for those decisions. And this extends not only to staff people who are doing these sorts of things, but all the way up to board members, governing bodies, and so on. Anybody who is an agent or otherwise involved in the purchasing activity needs to adhere to the code of conduct. Now, there are two major categories of policy related to this. The first is conflict of interest, and it makes clear that individuals who have a familial conflict of interest need to recuse themselves from a purchase. It talks about the employee or affected individual and any of their immediate family. Now, the problem is they don't define what immediate family is. So this is a place that an organization would step in and establish more clearly who is covered by this sort of arrangement. The policy in 318C establishes a minimum level of familial involvement. There's also an issue related to conflict of interest on a financial basis, where if somebody has an ownership interest in a potential contractor or has a family member who's an employee of a potential contractor, then that appears enough to be a conflict of interest to necessitate a recusal as well. Now, the third form of conflict of interest is organizational, and this really gets to something that's covered further down the list there, less than arm's length transactions. The federal government is very concerned that an organization might procure from itself or from some closely related party. And some of you, for example, have affiliated organizations that are under common control, under the same board of directors or governing body as your organization itself. that sort of thing is considered to be a conflict of interest as well. And OMB drills down deep on that, particularly as it relates to leases of property. So the idea that, say, an organization has a holding company for all of its assets and is renting from itself. Now, some of you might be, raising a question in your mind saying, does that kind of stuff really go on? Well, it certainly has, and that's one of the reasons why OMB has slammed the door on it in Section 200-465. OMB also gave federal agencies the ability to add supplemental federal agency procedures. That is, to go further than what Section 318C does. Now, I'm not clairvoyant about all the things that all the federal agencies have done in this particular area, but over the past several years, I've seen very little of any indication that a federal agency has stepped in and gone further than what the basic regulation requires. So unless you see something in a grant or sub-grant agreement that refers to Section 200-112, I think you're probably safe on that score. Now, the second aspect of Code of Conduct has to do with solicitation or acceptance of gratuities. And OMB says that a non-federal entity shall neither solicit nor accept anything of value from a contractor. But then they turn right around and say that an organization can set parameters related to items of nominal value. And so the idea is that you would have a purchasing procedure that says that, nobody on staff or part of a board or whatever should accept any or solicit or accept anything worth more than a specific dollar amount. And the numbers that I've most often seen in that situation are $10 and $25. The idea that if you accept a pen or a coffee cup from a contractor, that you're somehow compromising the purchasing procedure. But clearly, the situations where something a whole lot more valuable is shared might even be considered a bribe. So that's why, your organizational procedures need to define that situation. Now, the Code of Conduct also expects that there'll be disciplinary procedures and teeth in terms of enforcement. And not surprisingly, the failure to enforce the procedures is something that could lead to non-compliance as well. Finally, there are some what I'm referring to as new, they aren't as new as they once were, disclosure procedures contained in the regulation itself. And what it says is that an organization receiving a federal grant has an affirmative obligation to report violations of federal law related to fraud, bribery, or gratuity violations. Now, these are all contained in Title 18 of the United States Code, which is the federal government's criminal code. Okay? But the key word in that language is violations. So it's not allegations, it's not investigations, it's situations in which you found that there is something amiss related to those areas. Now, let's move over to slide number 7 and talk about acceptable methods of purchasing. And this is where getting into dollar amount stratification is a pretty common purchasing procedure feature. OMB introduces 5 different ways that purchasing can take place. And it is in these areas where the story I told you a little while ago about Congress getting involved in the discussion is most important. Quite frankly, the dollar figures that the Congress used, which were, after all, reacted to from some of the things that management of recipient organizations pointed out, are stratospheric compared to what normally goes on in most organizations that I'm familiar with. So let's start out with what the federal government refers to as a micro purchase. and that is purchases of less than $50,000 when certain conditions are met. Now, I don't know any organization that I've ever worked with in all my time as a consultant that treats a micro purchase with that kind of dollar figure. And so the role of the recipient or subrecipient's own micro purchase threshold is what kicks in here. In other words, you're allowed to have a micro purchase threshold that goes up to that number. But the likelihood is that your governing body and your top management doesn't want to go anywhere near that number. Okay? I've had contractual arrangements with a couple of the largest state governments in America, and their small purchase or micro purchase thresholds were in the $10,000 range. So here's a place where you need to fill in the blanks. But the important thing about a micro purchase is whatever that threshold is, you have no need to solicit competition. You can buy off the shelf. It's not big enough to bother with, is a way to think of it. Okay, I'm using colloquial expressions here, but that's what we're really talking about. Going through a convoluted and detailed process of purchasing doesn't make a lot of sense when you're shopping for something that's not all that expensive. Now, there's also a limited exception, and that has to do with the applicability of the Davis-Bacon Act, which is a Depression-era statute that says that in federal contracting and federally assisted contracting for construction, the people who do the work must be paid wages that are consistent with those established by the Department of Labor. And a construction project for Davis-Bacon purposes is anything that costs more than $2,000. So you could be repairing the bathroom and have the Davis-Bacon Act kick in on that arrangement. That doesn't mean you've got to go out and solicit competition, but it does mean that the people who work on the project need to be paid wages set by the Department of Labor. Now, the second type of purchasing is what's known as a small purchase. And the only place that small is as big as $250,000 is the federal government. Okay? That's what's referred to in the rules as the simplified acquisition threshold. Now, once again, the same principles that I introduced on micro purchase are relevant here. Your organization establishes what its own small purchase threshold is going to be. And then, once they have done so, expenditures that fall between the micro purchase threshold and the small purchase threshold are subject to gaining competition or quotations from what's called an adequate number of sources. Now, one of the urban legends that's out there in federal grant land is that you've got to get 3 bids. I challenge you to find anywhere in federal rule books where it says that. Okay? What it says is that you solicit quotations from an adequate number of sources. And many organizations select 3 on the assumption that if they do, that will help preclude collusion in the marketplace. All the contractors are not going to get together at the Holiday Inn and decide who gets the purchase. Okay? So, how you solicit those quotations, what methodologies you use, whether you go and get on the telephone to a number of organizations that might provide the goods or services you're after, something along those lines would be up to you. That type of arrangement is, the federal government doesn't get involved in that slippery slope of activity. Now, the third method of purchasing is competitive sealed bids, and this is where formal advertising is expected. Now, this is really a leftover from the days when publishing a invitation for bids in a newspaper having general circulation was the preferred method of getting the word out. Well, clearly, given the health of current newspapers and the existence of the internet, how formal advertising is done is not something the feds have drilled down on. but it's up to you to cast as wide a net as possible so that you are able to obtain competition. And the idea is that, normally this is going to result in a firm fixed price contract, either on a lump sum basis or on a unit cost basis. There are conditions that are established in the rules for the use of this, and by and large, they have to do with the nature of the marketplace. Are there a sufficient number of entities out there that can perform the work, deliver the goods or the services that are being obtained? And clearly, some of you come from areas where the nature of the marketplace doesn't have as many effective performers as some other places do. And so, how extensively you are able to generate those offers is certainly part of the issue here. In a competitive sealed bid situation, the award goes to the lowest responsive bidder. Okay? Responsible means it's an organization that is capable of doing the work and has a record of performance and integrity. Responsive means that they are capable of responding to the specifications or the scope of work that needs to be done. And if they are responsible and responsive, that's when the lowest price comes into play. Now, this is the preferred method for construction. And I recognize that a lot of you come from organizations who are not necessarily managing a competitive sealed bid process for your own organization, but are providing technical assistance to some of your member governments, particularly smaller ones, that might have gotten a grant to do construction, a water line or a sewer line or housing rehabilitation or something of those sorts. And as a consequence, you're helping manage the process on their behalf. Now, moving over to slide number 8, the fourth method of purchasing is what's known as competitive negotiation. And some people refer to it as the RFP process, request for proposals. In competitive negotiation, competition is expected, but the result may be a fixed price or a cost type contract resulting. Solicitation, the announcement of the request for proposals, identifies the evaluation criteria that will be used in selecting the successful contractor and their relative importance. Now, in many cases, this involves the assignment of a number of points. 20 points for experience, 20 points for assigned personnel. So price may be a factor, but it may not be the controlling factor. And you're expected to have written procedures for how you're going to conduct technical evaluation of proposals. Now, in this situation, the award goes to the most advantageous offer. By the way, that's a typo. It's supposed to say offer, not officer, with price and other identified factors involved. And this particular process has to be used for architect and engineering services because price cannot be used as a selection criteria. This is often referred to in familiar terminology as the Brooks Bill requirement, named for a late congressman from Texas, Jack Brooks, who had it put into federal law. Now, slide number 9 captures the fifth method of purchasing, non-competitive negotiation, also known as sole source. Now, OMB made sole source much more difficult with the requirements that came along in 2014. And what it basically established was that there are 4 justifications for sole source. The first is where the good or service is only available from a single source. Well, you've got to know an awful lot about the marketplace to know whether that's the case. The second is where the public exigency or emergency dictates it. In other words, you don't have the time necessary to go through the more established procedures of invitation for bids or request for proposals. Needless to say, this is something that comes up often in the FEMA environment. But it's also something that, by the way, the Department of Homeland Security, which is, the department that houses FEMA, is very concerned about when disasters are present. Their Inspector General is fond of saying, poor planning is not an emergency. The third situation is where it's authorized by the awarding agency. Now, this could be something that is established in the approved grant application, or it's something that could arise during performance where you go back to the awarding agency and say, we want a sole source to this organization, and here's our justification. And they can turn thumbs up or thumbs down on that sort of arrangement. I have no way of knowing how common it is for federal awarding agencies or pass-through entities to permit that sort of thing. But this is a door that might be open under certain circumstances. Now, the final method or a justification is where there's inadequate competition. But this is not something you know going in. The expectation is you'll go out for competition and you'll find that you don't get any offers, or the offers you get are not responsive or responsible. So at that point, you defer off to a sole source arrangement. Now, you'll see that acronym there, JOFOC. That stands for Justification for Other Than Free and Open Competition. So if you're going to use that inadequate competition basis, you better be prepared to write something up that justifies what's going on. Now, the final thing I need to mention in terms of the context of methods is the use of time and materials contracts, which is, just like it says, you're paying for time and materials. Okay. If you're a homeowner, you've probably run into this yourself, where a contractor comes in and looks at a job and says, I have no way of knowing what it's going to take to get this back to where you want it to be. Well, the government says if you're going to use a time and materials contract, it should be because no other contract type is suitable. In a time and materials contract, a ceiling price has to be established, not to exceed X dollars. And there is a requirement that the recipient or subrecipient engage in oversight to assure that the contractor carries things out efficiently and with the ability to control costs. In other words, you've got to watch them, and that clearly takes more effort than what might be occurring under another contract type. Now, let's move to slide number 10 and talk about some of the process activities that are going to go on in these procurements. And to start out with, let's use a term that actually doesn't show up in the regulations at all: acquisition planning. There are a number of provisions in the regulations that deal with these types of matters. First is the decision to purchase. There's a provision in the regulations that says you are supposed to avoid unnecessary purchases. And some people reading that language would say, well, duh. Of course we're not going to do unnecessary purchases. Except for the fact that a lot of organizations look at their grant budget and see, for example, that there's $40,000 in the budget for purchase of supplies, and think that that is authorization to spend $40,000 on supplies, even though they'll show by their performance they couldn't use all $40,000 worth of supplies. So having a bunch of stuff on hand at the end of a project or program is almost a giveaway that you purchased too much. The other thing they want you to do is to, even though you're authorized to purchase, consider alternatives, such as leasing it rather than purchasing it outright, or receiving third-party in-kind contributions, where somebody donates services or goods to your project or program. That's a great thing to have happen, and what it does is displace the need to expend funds on allowable cost. And finally, consider whether the federal government's excess and surplus property program might be a source of assets that could be used on a grant, particularly organizations from the K through 12 education sector and nonprofit community-based groups have a certain amount of preference in getting federal excess and surplus property. That's probably not going to help your organization particularly, but it may help one of your partners in that whole area. Now, another term of art the feds use, it's not in the regulations per se, but it certainly is, underlying a lot of their thought, is what is the procurement element of the grant budget? And I referred to this up front during my introduction. The standard form 424A is the budget form for a federal grant application. Some of you are familiar with it intimately. There are 8 object class categories of expenditure there. Personnel and fringe benefits are 2 of them. Personnel is wages and salaries of employees, and fringe benefits is just what it says, also related to employees. But then the other 6 are the ones listed there on slide 10. Travel, equipment, supplies, contractual, which primarily deals with services, construction, and my favorite, other. Virtually all of the expenditures made in those categories involve going through your purchasing system and using one of the methods that we just talked about. Now, moving over to slide number 11, let's talk about managing the supply chain. What do we mean by that? It means, how do you break up the transactions that you're going to engage in relative to purchasing? Are you going to bundle purchases together into a large element and purchase that way? Or are you going to break it out into smaller purchase transactions? Now, I'll get personal here. My wife is a great bundler. Okay? She loves to go to various kinds of warehouse outlets and buy 80 of something. And then we got to find a place to store it at the house. That's what bundling is all about. Breaking out, on the other hand, is engaging in smaller purchase transactions that may involve a lot more work, but also have, in some cases, benefits related to other parts of the regulations. For example, breaking purchases out into smaller pieces means that it's a lot easier to solicit and award contracts with small businesses, minority-owned businesses, women-owned businesses. Okay? They may not be big enough to handle a bundled contract, but they certainly might be able to handle one that's broken out into smaller pieces. So how an organization proceeds with those sorts of decisions also may involve the third bullet on slide 11, which is called value engineering. That's thinking about the life cycle cost of a particular purchase. So the idea of purchasing something, but also recognizing that there may need to be the ability to obtain spare parts or capability to repair, things of that nature may come into play as well. So buying the cheapest model may be a long-term bad decision if you've got to spend an awful lot of money keeping the asset in working condition and the like. Now, the other thing that they talk about in terms of acquisition planning, and certainly some regional organizations are intimately familiar with this arrangement, is cooperative purchasing. That is banding together with other purchasers to bundle a bigger purchase and attract more attention in terms of the marketplace. There are a number of regional councils of governments around the country who actually have cooperative purchasing programs for their own members, and they also make those services available to others. The one caution that I would introduce here is that if you engage in cooperative purchasing, you must make sure that whoever takes the lead in the purchase is following the federal rules as well. Okay? And there have been some cases where these issues have come up, where somebody relied on a lead purchaser, and the lead purchaser didn't do all of the things that were needed competitively. A variation on this theme is is something that probably a lot of you are familiar with as well. And that's where local governments or special districts are permitted to purchase off of state contracts. So the state enters into a contract competitively and then allows their governmental units to piggyback onto that contract and purchase under the same circumstances. As you can imagine, the marketplace contractors are very, very interested in being able to establish that sort of contract because of the volume of business that they are getting. Now, slide number 12 focuses on obtaining competition. And the term free and open competition is used throughout the federal regulations. The idea here is that you cast a wide net, and you can do so through a variety of means, including the creation of offerors lists. I mean, this is something that, I think a lot of organizations are guilty of not thinking about who the marketplace is until they actually have to make a purchase. It may make sense for an organization to periodically go out to the marketplace and say to the marketplace, here are the kinds of things that we buy on behalf of our own organization and perhaps on behalf of our members. We are interested in obtaining qualifications from individual firms or offerers who are capable of providing this. We're not making any purchases right now, but we want to have you on a list that when it comes time for us to make a purchase, we can go out to you and make sure that you get a copy of our solicitation and that you're aware of our needs. That kind of thing is certainly relevant. Some of you may have in your purchasing procedures, again, the concept of publishing a notice in a newspaper having general circulation, and the issue of whether they do or not is probably something you need to consider. Section 200-321 requires organizations to solicit entities from this list. Okay? So once again, gathering information about who those businesses are is an important step. And throughout the federal regulations, the uniform guidance, OMB uses the term must when they are identifying a mandatory requirement, and the word should when it's a good idea. Well, suffice it to say that the affirmative steps area, it says must. Now, here's a place where there has been some controversy and some policy change recently. First off, if you're spending federal funds, there is no state or local geographic preference allowed. It's prohibited because the money that's being spent comes from everywhere. And so saying that somebody's got to be from the state of chaos or the city of brotherly love isn't fair. Okay? That doesn't mean you can't say that the organization, the contractor, has to be able to perform in the location where necessary. But that's a different standard than where their headquarters is. Now, here's a place where we find not unseemly, that's not the right word, or an unlikely agreement between the Trump administration and the Biden administration has been manifested. And that's in the area of domestic preference. President Trump issued an executive order early in his presidency called Buy America, Hire America. And that executive order was translated into 2 CFR 200-322 that gives domestic preference encouragement. It's not an absolute requirement. The language is actually fairly flexible. But the bottom line is that the federal government's trying to use its own purchasing as well as grantee purchasing as a way to shore up the domestic economy. Well, when President Biden came into office, as you well know, there were a number of executive orders that he issued that overturned things that the Trump administration did. But one of the areas that was not surprising, it was actually pretty commonly understood, is that he issued a new executive order, number 14,004, which says in slightly different language the same things that Trump said earlier on in his administration. So, trying to buy American is seen to be good public policy. Slide 13, Developing Solicitations. Now, as we've heard from looking at the various methods of purchasing, the question of whether you've got to have a written solicitation may have to do with how much you're spending and how process-oriented your purchasing steps are going to be. But the nature of this activity states that contractors who are involved in creating the specifications or the statement of work cannot compete for the contract. And this is something that particularly in some technical areas can be pretty dicey. When you're talking about architect and engineering services, accounting and auditing services, things of that nature, you got to be very careful about how that's formulated. Now, the components of a solicitation, whether it's an invitation for bids or a request for proposals, needs to specify the features that are identified here on slide 13. What's the procurement method that you're engaged in? What is the expected contract type? In other words, we intend to issue a fixed price contract, or we intend to issue a cost type contract with a fixed fee as profit. Now, this is a place where, again, federal statute rears its head, because you are precluded from engaging in a cost plus percentage of cost contract. And that means a cost plus percentage of construction costs as well. Finally, identifying how contract financing is going to take place. And that's the term of art that has to do with how the contractor is going to get paid. What's the timing of that payment and what amounts? So the idea, particularly in larger, more complex contracts, may have to do with a payment schedule that's tied to benchmarks or achievement of certain interim objectives or things of that nature. And, contracts under grants are a place where retainage is okay. Retainage means you hold back some of the payment until you're assured of full performance of all work or delivery. Okay? Once again, being a homeowner is good practice for dealing with this sort of thing. When you decide to add a half bathroom and the contractor still has a punch list of things to do before you release the final payment, that's the kind of leverage you want to maintain in this situation. Now, over on slide 14, we go a little deeper on those solicitations. Invitation for bids, the terms of art we use are specifications. How is the asset that's being purchased characterized? And this is where OMB gets into the discussion of brand name or equal. So the idea is if you're going to identify brand name, you have to identify the salient features that the brand name item has so that other brands can offer their comparable goods. Again, the award goes to the lowest responsive responsible contractor. Request for proposals introduces a bunch of alphabet soup into the procurement process. And this is a place, for example, that some of you who are administering programs under the Older Americans Act or the Workforce Investment and Opportunity Act are going to be dealing with these sorts of things as you're engaging contractors to carry out services related to those functions. The statement of work is an identification of the process that the contractor has to go through and what their deliverables will be. What are the products or services that they're supposed to produce? The technical proposal instructions tell the potential contractor how to package their offer so that you can compare one offer to another and make a source selection. The technical evaluation criteria are the factors that are going to influence the decision to select the contractor. And that may be done in arithmetic or adjectival sources. Now, probably most of you are very familiar with the arithmetic approach, where a number of points is given for each of the evaluation criteria, probably adding up to 100. Or I have seen some where it adds up to 1,000, which is a little bizarre, but in any case, the full amount of points might be awarded. Adjectival arrangements are where the solicitation says the most important factor is going to be A, the second most important factor is going to be B, and so on down the line. And it's also possible that requests for proposals will be engaged in something known as a two-step procurement, where the first step in the procurement is to evaluate the technical capability of the potential contractor. And from that, a decision is made that there are a list of contractors who are capable of doing the work. So let's say that you've got 8 offers, and you review the 8 offers from a technical standpoint and determine that 5 of the offerers can do the work and 3 are not qualified. What you then do is you solicit the best and final offer from the 5 who are capable. And it doesn't matter what their score was on the original step. They're all considered equal at the point where you're now asking for, give us your price. And then you select based upon the low price among the qualified parties. Now, there are some special rules related to audit procurement. They're contained in 2 CFR 200-509. What I think is important about that is twofold. One is it shows just how concerned the federal government is that you engage an auditor who's going to be independent and capable of doing the audit. The other thing is that it actually goes into some detail about the kinds of evaluation criteria that are important for that kind of purchasing. And, it's kind of a mini camp on doing a request for proposals. So, you might want to take a look at that even if you're not in the business of procuring an audit right now. Slide 15 gets to the issue of source evaluation. And the notion here, for example, is, as we talked about earlier, responsiveness and responsibility. Responsiveness means that the potential contractor is providing the information necessary for you to make timely decisions on making the award. So their offer is in on time. It's complete in terms of what's been asked for. They don't have any gaps in what's involved. And it's correctly stated. In other words, they were on task in making sure that the offer was submitted to you in a way that you could make effective decisions using it. Responsibility has to do with references to their organizational integrity, their past performance, and so this is where asking for references and checking them is important. Compliance with public policy. Now, this may involve you checking behind the potential contractor to see if their corporate status is appropriate, to see whether they're up to date on taxes. And now that we've got substantial digital activity in all of our lives, checking on some of these things with access to the internet is a lot easier than it used to be. So, for example, checking their corporate status with the state Secretary of State, where they're incorporated, or the Attorney General's office to see if there are any pending judgments, with the State Department of Revenue to see if they're up to date on taxes. From place to place, this may vary to some degree, but you get the point. You want an organization that has got a record of organizational integrity. And finally, that they've got the financial and technical resources necessary to carry out the work. Do they have a line of credit? Are they insured? Things of that nature. Now, you want to see a big difference between situations in which you're awarding a contract and situations where you're awarding a subrecipient agreement. In many cases, awarding the subrecipient agreement involves awarding to the most needy organization, both in terms of the nature of the project and the nature of their beneficiaries. They need the money that's coming from a subrecipient arrangement. In a contract under a grant, what you're engaging is capability. And so having the financial and technical resource to do the work is important. Source evaluation involves the application of the evaluation criteria. And so information about scoring sheets, things of that nature come into play here as well. It's entirely possible that in some of your RFP activities, you'll engage in a multiple review process where several people are involved in reviewing the contract offers and scoring them, and the aggregate of those scores becomes the basis for making the selection. People looking at things from a slightly different standpoint may have an assessment that differs from one another. The old situation, if we ever have an Olympics again, of judging Olympic diving. The Russian judge is the hardest, and the Swiss is very lenient. Finally, there's an expectation of vetting and making sure that the organization that you contract with is not suspended or debarred by the federal government. The System for Award Management website is where you can find that out. And EPLS stands for Excluded Parties List System, which is a list of all the individuals and organizations who've been bounced out of doing federal assistance activities. The regulations on that whole subject are contained in 2 CFR 180. And by the way, independent auditors love this one. They'll look at your procurements and see whether you checked the EPLS list, because if you didn't, you could have entered into a contract with somebody who's suspended and debarred. You didn't, but you could have. And so this is a kind of an easy one to write you up on, where you've done something wrong, but it's not going to take a pound of flesh out of you from a disallowance standpoint. Another activity that deals with source evaluation is covered on slide 16, cost or price analysis. Now, this is required in all procurements that involve an amount over the simplified acquisition threshold. And as I pointed out earlier, the simplified acquisition threshold is $250,000. So, it's got to be a pretty big contract for you to have to do this. But what it involves is an assessment of whether, if you get a fixed price offer, how that compares to other fixed price offers. If, on the other hand, the offer is broken out by individual cost elements that go into a bottom line price, then you're assessing whether the amounts of those costs are necessary, reasonable, and allocable. In other words, does the contractor need to spend money on that type of element? Are the amounts involved reasonable? And is there sufficient benefit to the project to justify that? Now, this is where the uniform cost principles also apply to the activity. Okay, so it's a place where the federal government has introduced some of the concepts that it more readily carries out in its own procurements. Now, the source evaluation process hopefully is going to arrive at a source selection decision. Who is going to be the successful contractor? And at the top of page 17 of the slide deck, you have the reference to documentation. And I suggest to you that you avoid what some in the field call black box purchasing. Black box purchasing is where all the offers that are received go in one side of the black box, and the successful contractor comes out the other side and you can't tell what went on in the box. So transparency in terms of purchasing decision making is what's expected here. And keeping all of the information related to source evaluation by the individuals involved in those decisions and the ultimate decision itself is what's involved here. Err on the side of not only transparency but thoroughness. Now, here's a place where the rules are weak. That is, what's the result of that source selection? The predecessor requirements that led to the revision of the OMB circulars did a much better job with this. But that being said, I think from a practical standpoint, what you need to be aiming at is what those rules called a sound and complete agreement. Now, perhaps the lawyer that you rely on for other legal work can flesh this out even further for you. But think back if you ever took a course in school or in college about business law. What are the elements of a contract? The presence of an offer, acceptance. The offer is being made by the contractor, the acceptance being made by the grantee. Legal content, consideration, in other words, payment, the idea that you're not going to do this for nothing if you're the contractor. The jurisdiction, what's the governing law that's going to cover any disputes? What are the obligations of both parties? And what are the rights and remedies if those obligations are breached? And finally, severability, that if one provision of the contract is determined to be invalid, it doesn't invalidate the entire document. That's a starting point for what needs to be in the contract. Now, you might say, well, gee, that sounds like even micro purchases have to have a big document attached to it. Not necessarily. You may be able to achieve some of this by simply making reference to what constitutes a sound and complete agreement under the state law in the state where you're operating. But there are some things you have to reference that relate to the federal government, and that's the required federal clauses that are contained in Appendix Roman numeral 2 of 2 CFR 200. Now, as I pointed out earlier, we did not provide this to you in the handout material, but we are going to send to you after the program is over. We'll send you a copy of Appendix 2, and it's what we call in the business boilerplate language. But you can achieve the inclusion of those clauses either by completely restating them in the form that Appendix 2 does, or simply referencing them. In other words, putting into your purchase order document or into a formal contract text that says that the clauses contained in Appendix Roman numeral 2 of 2 CFR 200 are hereby adopted. The contractor is on notice that that's something they need to be aware of. You have no responsibility for providing them with technical assistance about what they're getting themselves involved in. They're big kids and they can handle it, we hope. Okay. Think about the contrast that you would have between that sort of approach in a contract under a grant and the approach you would use with a subrecipient, where providing them with technical assistance so that they can understand what they've gotten involved in and achieve their objectives is a much more common and hand-holding kind of approach. Now, slide 18 gets to the issue of contract administration. And this is kind of an interesting one. I say interesting because Section 203.18b is 2 sentences long. And what it entails is that you're going to, conduct contract administration so that you determine that the contractor has performed in accordance with the terms and conditions and has complied with those terms and conditions. Okay? It doesn't say anything about how that's to be done. And think about the contrast here again between what you would do under a contract under a grant versus subrecipient monitoring as it's established in the requirements related to subawards. In the federal rules on subrecipient monitoring are pretty explicit about the steps you need to take. 318B is largely silent on these things. So, one thing that you should expect is that you would have access to the contractor and its records to determine the degree to which they've adhered to the terms and conditions. That access, however, should avoid situations where you are interfering with their performance. In other words, if you get in the way too much, then the contractor may have a common law right to charge you for raising the cost of their doing business. Now, on the next page, we're going to get into this in just a moment, we can talk about some of the tools that are available for contract administration under fixed price contracts versus cost type contracts. But before we leave the contract administration point, let me also identify for you the rules the federal government has about you taking care of the stuff you bought. In other words, the property management standards. This is particularly important in areas like the purchase of equipment, where keeping records related to the equipment, certain data elements about what you've bought, and then what procedures you are using for keeping that material in good working condition and safeguarded against loss, damage, or theft, things of that nature as well. So purchasing segues into property management in any number of ways having to do with allowable costs of those purchases. Now, let's look a little deeper on slide 19 related to purchases of supplies and equipment. What are the things that are going to be contract administration steps? They're almost commonsensical. You and I, in our own, financial lives, have probably conducted lots of contract administration over the years. And one of the things you end up, trying to teach your children is to do a certain amount of contract administration themselves. I like to use my daughter as an example. When she was in our home and spending my money, her contract administration skills were sadly presented. Once she got married and was spending her money and her husband's and had a couple of little kids, suddenly her contract administration skills ratcheted up substantially. So what are we talking about here? Delivery, enforcing delivery related to supplies and equipment, conducting inspection, making sure that the equipment that you bought works, make sure that the accounts that you asked for are actually being presented. Because those particular steps lead to the question of whether you have accepted delivery and whether you are liable for paying for that. Now, the assumption as well is that payment may involve holding back a certain amount of the final payment until full delivery and acceptance has occurred. So you might be dealing with partial decisions on some of this stuff as well. And finally, the question of whether, and this would be particularly true in the purchase of equipment, whether there are warranties that can be enforced long after acceptance has occurred. Now, with respect to services and construction, we have a slight variation on the theme. Conducting of oversight of the work process may be part of what's involved. And think back to our discussion about time and materials contracts, and you get to that sort of approach. But then delivery of the services and inspection of whether the delivery is satisfactory leads to the question of whether the purchase involves acceptance and payment. And then again, in some certain circumstances, there will be warranties associated with those services or construction activities. Now, keeping up with all that you've done in purchasing involves generating procurement records. And Section 203.18I has an odd way of talking about this. It says that you must keep records that relate to the significant history of the procurement. And they're really talking about an audit trail from the beginning of the purchase all the way through acceptance and payment. At a minimum, that history of the procurement involves at least the four elements that you see on slide 20. The rationale for the procurement method that you chose. So within your policies, you chose micro purchase, small purchase, invitation for bids, request for proposals, non-competitive negotiation. Which of those was involved? What's your rationale for the selection of contract type? Did you use a fixed price contract, a fixed unit price, a cost contract with some additional increment, cost plus a fixed fee, for example? As long as it's not cost plus percentage of cost, it is an acceptable method. The basis for source evaluation and selection, and this gets back to my point about black box purchasing, making sure that you have sufficient information that shows who you got offers from and how you culled away those offers down to the selection of a successful contractor. And finally, what's the basis for the contract price? Now, that's not hard to do when you're soliciting on a fixed price basis. What you do is hold all the acceptable offers up against one another and establish how you selected the successful contractor there. On the other hand, if you are dealing with a contract where you solicited the contractor to break out the individual elements of cost that go into the bottom line price, then how did you assess those costs? When you're doing cost analysis of a contract proposal, one of the things you're going to be asking the contractor, if they haven't provided it as part of their offer, is where did you get your numbers? What's the cost reality here? Okay, so those are things that would need to be expected as well. Now, earlier in the presentation, I said that there are some federal agencies that are more interested in procurement than others. Well, one of the federal agencies is the Department of Justice. And before the pandemic started, a couple months before it, the Department of Justice formulated a 13-agency task force called the Procurement Collusion Task Force. Now, this activity involved both procurement collusion at the federal level. In other words, where offerers on federal contracts were colluding in the marketplace. But obviously, it was also equally concerned with that sort of behavior in the grantee community. And this has only been ratcheted up substantially because of the financial response to the pandemic. There is another group, I don't have it on the list here, but I will tell you what it's called. It's called the PRAC, P-R-A-C, Pandemic Response Accountability Committee. This is a 21-agency function, chaired by the Inspector General of the Department of Justice and made up of Inspector Generals and investigatory personnel from throughout the federal government. When Congress passed the CARES Act, they kicked in substantial money to beef up those capabilities so that, all this spending that's taking place is taking place under a sunlight of accountability. So, suffice it to say that, the federal government recognized the potential for problems here just because of the sheer size of those activities. But going further, which federal agencies care most about procurement? Well, I've mentioned a couple of them already. Department of Transportation is probably the agency where this is most important in their grants administration. The Environmental Protection Agency, Department of Housing and Urban Development, the Community Development Block Grant Program, and other housing-related activities in HUD involve substantial procurements. If we go over to the Department of Health and Human Services and the Department of Labor, we're dealing with social service procurement, where you're buying the services, for example, under the Older Americans Act, for contractors to provide home-delivered meals or transportation services or other things of this nature. The entities who are involved in the delivery of those services, those service providers are being procured. They are not getting assistance. Department of Labor programs, particularly Workforce Investment and Opportunity Act, WIOA, the procurement requirements that we've talked about here are weaved throughout the programmatic regulations and referred to separately in any number of places. You can find out more about why some of these agencies care by looking at the audits that have been conducted related to agencies that are carrying out these sorts of procurements. The inspectors general have a website, ignet.gov, which links you up with every inspector general's office in the government. And taking a look at some of the more prominent agencies on this subject is a lesson in what can go wrong in grants administration related to procurement. So, go online to ignet.gov, link up with the Inspector General of the agencies your organization does business with directly or gets pass-through money where it originated at the federal level, and take a look at some of the things that have happened. You can go back 6 months or you can go back 6 years. Most of the IGs have archived the last 10 years of their audits as a warning to, this is what we're after when we come looking. And finally, with respect to single audits, which of course are the audits that your organization has to cause to be performed under the Single Audit Act and Subpart F of 2 CFR 200. If you're looking for the vulnerable areas on procurement there, the best place to look is what's known as the Compliance Supplement, issued by the Office of Management and Budget annually. This is essentially an audit guide, and the last one for 2020 was issued in November of last year. Part 3 of the Compliance Supplement has an element in it on procurement and suspension and debarment, where OMB identifies the requirements that the auditor is supposed to determine whether you've complied with, and suggests audit procedures that the auditor can use to make that determination. I would suggest to you that is the Cliff's Notes of grants administration on the subject of procurement. Okay, if you'll take a look at that and get yourself in line with it, I think you're going to be in the sunshine when the auditors come to look at your compliance. What do they care about? The list of things that we've just gone through are places where the vulnerabilities are there. Suspension and debarment, as I pointed out, is an easy one. Conflict of interest is another one. And non-competitive activity. In other words, engaging in sole source procurement when there isn't a justification for doing so. Now, funding under the CARES Act was supposed to be committed or obligated by the end of December 2020. The fact that it might be obligated by a state government or by a large local government doesn't mean that it's all been dispersed. And so the likelihood is that there will be a fair amount of attention to procurements that an organization may have made using CARES Act funding. And if you were a subrecipient of some of those funds, I think it'd be wise to be prepared for that as well. Now, that takes care of what I need to cover related to all this, but I'm sure that there are some of you who've got questions that you want to raise, and I'm going to turn it back over to Laurie and let her run through what's in the chat box or what's going to be added to it as we speak.
Well, thank you, Bob. Once again, just being part of listening to the webinar, I learned some things that will be useful for our grants management. We actually just have one question again, so I guess you were very thorough. Somebody wanted to know, if you are a political subdivision of the state, do you follow guidelines for states or others?
If you are a political subdivision of the state, you follow what is for others, unless the state law explicitly says that you are required to follow state law related to the state's own procurement. In other words, this gets back to the point I was making, and maybe I need to clarify this. I mean, it's almost a case-by-case situation, because each state government has policies that relate to how state agencies are to behave. That's pretty clearly within their bailiwick. But they also, in many cases, have state law that says how political subdivisions, cities and counties, corporations that are incorporated under state law, how they are supposed to behave as well. And so those may be different than what the state law is relative to the state government. So I'm not sure. I mean, this might be something that if the questioner wants to explore this further, there's some contact information on the last slide. I'll be glad to follow up that way to try to get to a definitive answer. But I hate to say it depends, but it really does depend on what the state law says about the powers, duties, and responsibilities of a political subdivision of the state.
Okay, we just had another question pop up. Somebody wants to know if there are any sample policies, procurement templates, or other best practices that can be shared that we can review. His organization is in the process of doing a significant revamp of their policies, and seeing examples would be really helpful.
Okay, well, the answer to that is there are things out there that you can certainly rely on. What I think makes the most sense in terms of getting some examples that may have the blessing of the federal government on them is that most of the agencies that have significant grant procurements going on, and again, that would be places like DOT and EPA and HUD, have generally paid for technical assistance documents to be developed. That's where some of the kinds of samples that the questioner is raising might be most readily obtainable. Going on the websites of the agencies and Googling grantee procurement or technical assistance materials, that sort of thing. It is primarily guidance rather than regulation. In other words, it's best practices, that sort of thing. I've certainly got some examples in my own files related to that, and have done some engagements where I've developed a purchasing manual for an organization. Some of those things are proprietary, but that's the way I'd start down the road of doing so. And this is also a case where there's nothing to preclude, comparing notes with other similarly situated organizations. I mean, if you're a regional organization in a particular state, your colleagues in the other regions may be as good a resource as any on this particular subject. Let me give you one federal agency that I think I would use as the benchmark for this sort of thing, and that's the Inspector General's Office of the Department of Homeland Security. They've probably faced every weird procurement challenge, and they have. One of the things the IG has done there is periodically issue what they call management alerts. And these management alerts are kind of a summary of what they think the best practices are in the field, because they're saying to management of grantees who get FEMA money, these are the things we're going to be looking for. So here's a way for you to respond to those requirements. Okay, so there's some starting points for your efforts.
Okay, we have a couple of more questions. Somebody wants to know if working with a contractor to try to determine the budget for a project prohibit that contractor from bidding on the project.
I don't think that working on the budget for it does. The way the term is used in the regulations is it says if the contractor is involved in preparing the solicitation. Now, preparing the solicitation is preparing the invitation for bids or the request for proposals. Arguably, if the contractor was involved in helping you estimate what it should cost, that's not the same as the solicitation itself. Somebody might argue that gives them a competitive advantage, but for heaven's sakes, when you publicize an invitation for bids or a request for proposals, don't tell them what the budget is, the total. I can't tell you the number of times I've seen solicitations where somebody, particularly in the solicitation for services, they'll put out an RFP and say, we're soliciting the following kinds of services. The budget for this is $50,000. That guarantees you're going to get a lot of $49,000 offers.
Okay, another question says, you mentioned that it was prohibited. Hold on. You mentioned that it was prohibited for a cost plus percentage of cost contract.
Right.
In our state, they allow our contractor to have up to 10% of costs as profit for our transit service. Because of CARES Act, we are doing a cost reimbursement to our contractor, including a 10% profit based on costs. Is that a violation of the rules?
Sounds to me like it is.
Okay. Is the domestic preference encouraged, formerly known as the Iron and Steel Act? We have some municipal members who are adamant that they must follow this act in their procurement.
Well, that's where it all came from. Some of you will remember back during the Obama administration, the so-called stimulus, which was the American Recovery and Reinvestment Act, had an extensive discussion about protection of the iron and steel industries because of the nature of the contracting that was going to be done. I mean, we'll see whether President Biden's infrastructure bill will ever pass, but I've not seen the draft legislation, but I can almost guarantee the same provisions are in there that were in the era or the stimulus legislation. Well, the executive order that President Trump issued that resulted in 2 CFR 200-322 explicitly talks about iron and steel and manufactured goods. And so, it's intended to carry over to that particular provision. 200-322 took effect November 12th, 2020, and nothing that the Biden administration has done is to change that regulation. If they were to try to change it, they'd have to go to rulemaking, publish it in the Federal Register, take comments on it, and then finalize it. And I don't think they're going to go anywhere near that. So, that's the likelihood is that what is being asserted by your local governments there is based on accurate information.
Okay, it looks like we have one final question, Bob. I need to get proposals for an audiovisual system and installation. May I use a contractor to assist with that as long as I do not tell them the grant award amount?
Well, I mean, again, the question is whether what you're going to announce to the marketplace is something that they've had a role in creating. And the concern is that they will create or help you create something that gives them a competitive advantage. So, I think the answer to that is, what is the solicitation going to look like as to whether or not there's a conflict for the contractor. As far as identifying the amounts that you may be in a position to spend, one of the things I didn't mention in fashioning the solicitation is to say to the marketplace that you reserve the right not to place a contract at all. In other words, to decide that based on the offers you received, you don't have enough money to do it. I mean, that's a right you ought to have preserved in your solicitation. And one of the other protective things that can be done as well is to say that you have the authority to waive technicalities and to place a contract that's in the best interest of your organization. Those are both kind of protective things that it makes sense to put into the solicitation.
Well, great. Thank you so much, Bob. These were great questions, and I'm glad we had time to go through them. I think that's it. I just wanted to remind the attendees that you will receive a link to the recorded webinar and some additional handouts that Bob mentioned earlier in a few days once we have the recording ready to go. And you should get a request to complete an evaluation for today's webinar. We really hope you do that. It helps us plan future webinars and training events. So that's it. Thank you very much, Bob. We appreciate your time and expertise today, as well as throughout this 3-part series of webinars. As always, your information sharing was invaluable. So with that, I'd like to conclude today's webinar. Thank you.